I think it is clear to believe in the power of ideas.
Fresh thinking of the Manhattan Institute.
Then it's my pleasure to welcome you here and to introduce Lisa Rickard. We're doing this as a joint. This is a study that you have in front of you, Think Globally, Sue Locally, that is a study of the Institute for Legal Reform at the U.S. Chamber of Commerce, which Lisa heads. She's done such an outstanding job in that role. She's now been promoted to Executive Vice President of the U.S. Chamber of Commerce more broadly. It's been my pleasure to work with Lisa over the last 7+ years. We came on at about the same time in 2003. The Manhattan Institute, as many of you know, has been involved for some 25 years in the effort to reform our nation's civil litigation system. The U.S. Chamber, while it's always been interested in this, really took it to a new level about 11 years ago under the leadership of the U.S. Chamber's president, Tom Donahue, and he brought in Lisa to head this effort in 2003. The same year that I started at MI, and started, among many other projects, one called Trial Lawyers, Inc., and there's a couple of our more recent Trial Lawyers, Inc. reports out there. The premise behind this Trial Lawyers, Inc. concept was the tactics used by the plaintiff's bar mimic those of businesses and often shade ethical boundaries or come against the line of ethical boundaries in many of their tactics. Many of these are going to be detailed for you today in this new report released by the U.S. Chamber's Institute for Legal Reform in an international context. So it's my pleasure to welcome you. It's been a very fruitful friendship and partnership that we've shared with the U.S. Chamber, and notwithstanding some of the horror stories you're getting ready to hear, we have had some good results. From the year when Lisa and I started through 2008, which is the most recent year for which data is available, the percentage of the tort litigation as a percentage of the U.S. economy fell every year. Now, some of that's going to turn around with some of the recent events in the Gulf of Mexico and on Wall Street. So that's not. I don't want to promise that trend's going to be sustained. But we've had a lot of successes: the Class Action Fairness Act in Washington, tort reform efforts in various states, and so much of that is due to the outstanding leadership of Lisa Rickard. Lisa.
Thank you, Jim. We truly have had a great partnership, and I look forward to more events like this one. Sorry for the delay, folks, and I hope everybody has a study. If you don't, there are some extras, and we can get one to you. I think we're going to do our best to try to get you to follow along to the degree we can, but Jonathan has this all on the top of his head. Anyway, as Jim mentioned, the U.S. Chamber Institute for Legal Reform was created over a decade ago to serve as the advocacy voice of the U.S. business community in addressing our nation's litigation explosion. And we're here today to present the findings of a new study that reveals a very sophisticated and disturbing new litigation trend wreaking havoc on transnational business. The trend involves plaintiffs' lawyers targeting U.S. and multinational companies for their activities overseas using a wide array of common tactics designed to leverage public, investor, interest group, and media pressure to get major judgments and to extort large settlements. But while each of the cases appears unique, with seemingly unconnected events surrounding the lawsuits, upon closer inspection, we realized that many of the lawsuits contained similar elements and tactics. It was as if the trial lawyers involved were all working off the same playbook. Through a combination of media reports, court records, and other public documents, ILR began piecing together this puzzle, which ultimately began to take on the appearance of a model of sorts. And we realized that we needed to conduct extensive research in order to document what we came to understand were commonly employed abusive and unscrupulous tactics. Ultimately, we chose to work with Jonathan Drimmer, a recognized authority on the Alien Tort Statute and other issues associated with international law. Working with ILR, Jonathan conducted the research that we're releasing today, which is called Think Globally, Sue Locally, out-of-court tactics employed by plaintiffs, their lawyers, and their advocates in transnational tort cases. This paper is the first ever comprehensive look at the strategies employed in these cases. More likely than not, this model involves multifaceted campaigns against businesses using both legal and extra-legal strategies. Additionally, in the most extreme cases, we've even seen instances of local and U.S. lawyers engaging in corrupt practices, including coaching witnesses to lie, fabricating injuries, and in submitting false evidence. This report makes clear that for some time now, international attorneys and their allies have been playing off a common trial lawyer playbook designed to hold the reputation of companies hostage in order to gain the litigation upper hand. By exposing their playbook, we're informing the global business community of the trial bar's tactics so that companies are prepared to combat these practices. We also hope to encourage a discussion about the role that basic fairness, the rule of law, and ethics plays in whether and how to pursue lawsuits against companies for their activities in foreign jurisdictions. With that, I'm pleased to welcome Jonathan Drimmer to present the report. Thanks.
Thank you, Lisa. Thank you, everybody. Thank you to the Manhattan Institute for sponsoring this event. I'm sorry about the PowerPoint. I assure you it was memorable. You would have laughed and cried and carried it with you always, but we'll try to move on without it. But by way of introduction, over the past 15 years, there has been a dramatic rise in the number of transnational tort lawsuits that have been filed. And in the report itself, we talk about that starting on page 17 with a very colorful graph that helps illustrate the point. By way of transnational torts, what we mean is cases involving foreign plaintiffs, overseas injuries, and corporate defendants, either, as Lisa mentions, U.S. companies or multinational companies with a substantial U.S. presence. These are brought in the United States often under the Alien Tort Statute, which Professor Stewart is going to touch on during his remarks, but also under other theories as well. And a number of these cases are filed abroad in foreign domestic courts, with the plaintiffs then seeking to import any judgment to the United States for enforcement. And I believe Professor Koo is going to be talking about that aspect of these cases. When you look at these cases themselves, just as limiting it to the four corners of the cases, what you see, and we spell this out in the discussion starting on page 17, are a number of clear patterns, a clear number of litigation patterns. More than half of the cases are filed either in New York or in California, and this is focusing on the alien tort cases. More than half are filed by a relatively small group of plaintiffs' lawyers, NGOs, and public interest firms. You see clear industry clusters, particularly for extractive companies and companies in the financial services industries. You see clusters as to the underlying facts that give rise to these cases. But what we see, and as the bar chart on page 17 reveals, is the dramatic increase in these cases, certainly suggesting that as we've had an expansion of the global marketplace, the plaintiffs' lawyers have been following close behind. Geographically, these tend to come more often than not from emerging markets, but really will can arise from just about anywhere. But there is a prevalence, another cluster comes out of emerging markets. This study, though, that you have today doesn't look at those litigation-oriented trends. What instead it looks at is the out-of-court tactics that often accompany them. And for those of us who work in this area or companies that may operate in this area or ILR and others, we've all seen these happen on sort of one-off bases. I mean, we all have seen these tactics in our individual cases. But one thing that hasn't been looked at, and what this paper does, is to look at the trends among the tactics to try to discern, is there a pattern between them? Are there clear trends associated with the tactics being used? And when Lisa and I first sat down to talk about this, we didn't have the slightest idea what we were going to. We didn't know if the grid that appears in Appendix A would have no checks next to it at all. So we were really starting with a blank slate from the trend analysis. What we ended up doing is we looked largely at cases in U.S. courts, some under the Alien Tort Statute, some under other theories. We looked at some cases that are being litigated abroad. We identified and we tried to pick a diverse set of cases based on different underlying facts coming from different countries with different lawyers filed over different time periods to try to give ourselves a broad array in terms of the trends and being able to differentiate what is going on. We picked 25 cases, some of which had been consolidated. There are 40 individual filings in all, and Appendix A, which is I think page 93 or so, has that grid for you. We started with 20 tactics, and as we started to do the analysis, we were identifying some clear additional tactics as well, and it ends up studying 24 tactics for these 25 cases. All of our conclusions, as you see from the 413 footnotes, are based on publicly available information. To that end, it's probably worth noting that, if anything, this study is it's conservative in its approach. The findings they're probably much more pronounced, the tactics, than we find. The reason is the methodological limitations of relying only on publicly available information or information that we were able to ascertain. But that was the limit that we ultimately put on ourselves. As the grid on Appendix A, which is page 83, I see in my notes, reveals, you have 19 of the 25 cases have 10 or more tactics. Those are the blue lines that are going down. For the 6 that don't have 10 or more tactics, for most they're pretty easy explanations. They were filed in the 1990s or litigated in the 90s before these tactics began gaining real prominence, and I'll talk about the timing issues in a second. Or there was a gag order in one case, or a case was dismissed relatively quickly, or it's a less well-known defendant. And so they're, for the most part, the ones that don't have the blue line associated with them, there are explanations for it. The yellow lines going across show that there are 10 or more the tactics are being used 10 or more times. And for those, again, you see that the vast majority of these tactics are being used repeatedly by plaintiffs or their advocates in the cases that we ended up studying. We categorize the tactics in 4 different categories. We put them into 4 different buckets: media, community organizing, investment, and political tactics. And I'll go through those. I'll give you a little bit of a sense of general observations beforehand, talk a little bit about the case studies that we did, which help illustrate some of our conclusions, make some final concluding remarks, and then turn it over to the rest of the panel. I mentioned the variance in the cases, but there's one other general pattern or trend that I do want to remark on, and this is an important one. This is the timing trend, and this is one that I alluded to a minute ago. It is just as we've had a rise in the transnational tort cases, we have also observed, based on the study, a sharp rise in the number of tactics that are being used. The cases in the 1990s had far fewer tactics than what we're seeing in the 2000s. Those that are being litigated, filed in the 90s, and litigated in the 2000s, you see a sharp rise of tactics. We're seeing plaintiffs' lawyers learn from each other, observe each other's cases, and pick up new strategies. They will work together in cases and then ultimately go their separate ways and employ the tactics that they learned. So what we're seeing is, with the growth of cases, a growth of tactics as well. The other timing piece that I want to mention is a lot of these tactics are timed to coincide with various events or with each other. And there was an op-ed that we put out this morning in the Wall Street Journal that notes the Coca-Cola case, which is a documentary that was made that follows the lawyers who filed a series of cases against Coca-Cola around in their efforts. A new lawsuit was filed here in New York against Coca-Cola that was essentially timed to coincide with the release of the movie. And so the filing of the case will bring additional publicity to the film, and the film, of course, will bring additional publicity to the case. But you see these tactics being used interchangeably, and we note several of those throughout the study itself. On page 58, we talk about media tactics, which is the most prominent of the tactics that we see, most prominent category of tactics that we see. Print, radio, and television, overwhelming. Almost, I think every case actually had print, radio, and television associated with it, one or the other, print, radio, or television. Most often, these are on regional or local levels. Sometimes they are on national levels. And for the most part, these tend to be pro-plaintiff presentations in different ways, and we'll talk about that when we get to the case studies in a second. But one thing that they often are accompanied by, or these cases are accompanied by, and they work in tandem with these media efforts, are Internet campaigns. And particularly when you look at the cases that are filed in the 2000s, you see these Internet sites that are set up that are almost the mother nest for these out-of-court tactics. They have everything associated with it, calls to action. They'll have links to videos, links to stories, letter-writing campaigns, email campaigns, planned boycotts, planned protests, on-campus efforts. You name it, it is housed here on the websites. And while the websites have appeal largely to the existing followers, there are also media links, press kits, things that are designed to be attractive to larger, more mainstream audiences. And one thing we did observe is when we see the major news outlets, not on a regional or local level, but national news outlets put out stories, the Internet traffic to these sites always ends up shooting way up. And so it does look like the mainstream media sources will derive people to these websites where the advocacy for the efforts is housed and can continue. One other media piece I want to mention, and I mention it because it's a little bit of a surprising result to us. I mean, we had anticipated finding that for the most part, the tactics we would see would be those that were inexpensive, easy to do, could be done relatively quickly. An Internet campaign, for instance, would fall into that. But films, documentaries, and mini-documentaries we saw in a majority of the cases. And that was a little bit surprising given the effort that has to go in to making these. And certainly the Coca-Cola case, the documentary about the plaintiffs' lawyers in these Coke lawsuits, would be an example of that. And we saw that type of thing in, as I say, a majority of the cases. I want to mention, though, within that, a new and emerging concept, a new emerging tactic. It's called the mini-documentary. And these are about 10 to 12 minutes long. And the best comparison I can make is to almost like a political campaign video. They're slick, they're well-produced. One of them has a celebrity narrator associated with it, Daryl Hannah, who's been active in environmental issues. They're viral. They can get sent around via email. They're posted on the plaintiff sites and other sympathizers' sites. And in 10 to 12 minutes, they can present a very powerful story with evidence, with the plaintiffs' lawyers, trying to make the case. And for instance, for one that we looked at that was released in connection with a lawsuit here in New York involving Shell, on one of the sites alone, and as I say, these are posted in a lot of different places, it had more than 100,000 hits associated with it. So people are looking at these and are clicking on these when they are put out there. You'll see in the study and in Appendix A, other tactics include press releases, press conferences, and these will often generate some of the media attention, issue reports, speaking seminars, and things along those lines. To move on to Category 2, which is the community organizing tactics, which we talk about on page 69. This one I can't say I was terribly surprised by our findings here, and I'll mention just a couple of them. As I said at the outset, a lot of these cases are filed by NGOs and public interest firms, and certainly they will have plenty of like-minded organizations that they know, work with, and are familiar with. And in most of the cases, you do find the plaintiffs or their advocates partnering with like-minded organizations to get the message out, get the word out, and ultimately launch these kinds of tactics. Worth noting as sort of an aside, in 6 of the cases, we actually identified NGOs being created specifically to help advocate these types of tactics. New NGOs were created for purposes of the lawsuit, and in I think 3 of the cases, there were institutional plaintiffs who were NGOs themselves, again giving a sense of who is ultimately driving these. In most of the cases, particularly against well-known corporate defendants, we saw boycotts, protests, things along those lines that again fall into the community organizing category. Investment tactics. This is another one I want to mention and spend just a second on, because this was one that I didn't expect to see as much as I did, and it's a growing tactic. It's something that we are seeing a lot more of now than we did even just a few years ago. Often you'll have shareholder resolutions that are introduced. That's been going on for a while. They almost always fail, but you certainly do see a lot of shareholder resolutions introduced. And I should say, the purpose of the investment tactics appears to be creating some type of investment-related stress for the company. The company is concerned about possible stock issues, market capitalizations, access to financing, whatever it might be. And that does seem to be the purpose of these efforts. I will say that they don't seem to work in large part. We haven't seen any stock drops or things along those lines. That does appear to be where these ultimately are headed. I mentioned resolutions. Obviously, it's a place where a plaintiff or their advocate can air their grievances to the C-suite and to other shareholders. Often there'll be media attention surrounding that. One thing I do want to mention specifically is, and this is part of the new piece, shareholder resolutions aren't so new in terms of these cases, but we're seeing growing pressures on institutional investors. Pension funds, mutual funds, they will often be the ones who are pushed or encouraged to introduce these resolutions. We've seen several divestment campaigns, divestment pressures on institutional investors, and those have succeeded in small parts. They haven't dramatically impacted stock price on an overall basis, but there have been we did note several instances of fairly substantial divestments in the cases that we looked at, including increasing pressures on institutional investors. And I should note, to follow along, the investment tactics we talk about starting on page 74. The fourth category is political tactics, and that starts on page 77. This was the least frequent of the 4 categories. One thing that we did see, though, and this is also an emerging trend, I would say, is the use of congressional hearings that are timed to trials. We saw 10 instances in which cases were discussed in congressional hearings, but in 2 instances, and there haven't been that many major transnational tort trials in the United States, but before 2 of them, congressional hearings were scheduled with plaintiffs, advocates getting up there and making their case, and the timing of it, it's really hard to imagine that it's coincidental. And so certainly you have to conclude that the use of congressional hearings is something designed to again, bring additional pressures on corporations. Local resolutions, having members of Congress advocate or write letters on behalf of the plaintiffs or their advocates, submissions from foreign governments. These are some of the other political tactics that we did identify and that we do talk about, again, starting on page 77. One thing that we also talk about throughout the paper, and I want to touch on it here. There are two additional, we'll call it general issues. One is the motive. Why are these tactics being used? And we conclude that there are two primary motives. The first, and this seems to be true in the majority of the cases, is what we call a holistic litigation approach, a desire ultimately to pressure companies inside the courtroom through these tactics outside the courtroom, whether it's to generate additional settlements, to punish them, make them pay the price for continuing to litigate, for continuing to fight, that kind of a thing. I think in no small part, and this is more of an observation than a finding, in no small part, the historical lack of success on the merits in these cases, plaintiffs tend not to win these cases by any substantial margin, although we do have a number of cases that we studied where there were settlements or favorable outcomes to plaintiffs. I think that impacts the use of these tactics. The fact that historically they have not been successful in these cases probably helps inspire a motive to use these tactics to try to compensate for the traditional lack of success, trying to level the playing field and going against corporations through using these tactics and helping compel settlements, even though historically the facts haven't been there for them in these cases. There's a smaller set of cases that we do have conclusions on that don't share this holistic litigation approach. And when we first looked at them, we were scratching our heads a little bit as we were getting into them. There are these lawsuits that are filed that you look at, and as an attorney, you look at them and they just have absolutely no chance of success. I mean, they are destined not to succeed. And for instance, there was a lawsuit that was filed after years of litigation involving similar cases, relatives of these plaintiffs, same defendant company, they're all dismissed. A new lawsuit is filed that's virtually identical to the ones that had just been litigated and dismissed. And you look at this case, and there's no prospect of success at all. And for this smaller set of cases, we identify a separate motive and reach findings on a different motive than the holistic litigation approach. For these, the litigation itself is almost a tactic. You file the case, you get media publicity associated with it, you have events that are organized around it. It keeps the story in the news for at least a few weeks, maybe a few months, until the dismissal. And the dismissals are almost never on the facts. They're almost always, on some legal point. And so ultimately, it helps keep the story alive and in the press, even though there's really no possibility of a positive outcome in the litigation for the plaintiffs. In that sense, this other set of cases, which are often connected to larger corporate campaigns, are tactics unto themselves. But those are the two primary motives. We identify the holistic litigation approach, A, and B, in a smaller set of cases, the use of litigation as a tactic. One additional observation that we make that may be touched on by other panelists later, and I'm looking forward to hearing Rich's comment as well on some of these tactics that are used potentially in domestic cases, since I focus really here on the transnational side, is the rule of law concerns. And this is something that may be more unique to the transnational side. When you look at these cases, we found a higher number of instances where there is some type of litigation misconduct than we expected to find. And you take a step back and you look at these tactics, and in the United States, certainly these may place certain pressures on corporations. They may impact stock prices. But when you look at the litigation abroad, these pressures on susceptible courts can have a demonstrable outcome in the litigation itself. For a susceptible court that can be swayed by political influences and other types of tactics, the results won't necessarily yield rulings, decisions, judgments that comport with what we would consider rule of law in a U.S. sense. But even for the U.S. cases, and that becomes true in the case studies, as you'll see in just a second when I talk about those. But even for the U.S. litigation, we did find evidence of plaintiff misconduct, and I think and our conclusion is you look at the basic facts, the basic posture of these matters. You've got plaintiffs in these emerging markets who are often just highly impoverished. They live in abject poverty. You've got plaintiffs' lawyers who are acting they're zealous from greed, from cause, from whatever it is. You've got difficulty in amassing evidence and conducting discovery and litigating cases, and in sometimes foreign laws that make it very hard to do so. And you combine all of these facts, and it's really a recipe for potential misconduct. And I think in the transnational tort context, you are going to see a higher level of incidents of misconduct, often that is difficult to uncover, than you might on the domestic side. Let's talk about the two case studies where these primary conclusions, the tactics, the motives, the rule of law concerns, really can be seen. And the first starts on page 22 in our study, and this involves the use of DBCP, a pesticide, in Nicaragua. The basic setup is this pesticide was used on plantations in the United States, outside the United States, for a number of years. Cases have been brought in the United States. They started being brought in the 1980s and were roundly dismissed, typically on forum non-convenience grounds. In other words, they didn't belong in the United States. The litigation more properly should have gone on abroad, and you had courts making explicit statements about this being express global forum shopping and things along those lines. So they're dismissed in large numbers. The plaintiffs and local supportive groups lobby to get a law passed called Special Law 364. And the basic premise of 364 is to create, it's a blocking statute, and there are others in emerging markets that have their own take on this. But the basic purpose is to create a litigating regime that is so hostile to corporate defendants in these kinds of cases that they will choose to exercise the opt-out right that exists in the law and come back to the United States. It's designed to circumvent the forum non-convenience dismissals, the forum shopping-related dismissals, by creating a very hostile domestic litigating environment. So after this law gets passed, you have this influx of plaintiffs' lawyers, U.S. plaintiffs' lawyers, to Nicaragua to find plaintiffs to try to drum up lawsuits. And a number of lawsuits, of course, get filed both in Nicaragua and here in the United States. In connection with these lawsuits, you see the out-of-court tactics that we talk about throughout the study, use of the media, political pressures, those types of things. But one problem that the plaintiffs' lawyers had in these cases is they were having a difficult time finding plaintiffs who qualified, those who worked on banana plantations, and that was what these cases were based on, working on exposure to pesticide on banana plantations. And even more trouble finding people who are actually suffering relevant ill effects from having worked on banana plantations. And so as judicial findings coming out of a court in Los Angeles reveal, what the plaintiffs' lawyers did is they essentially created a vast conspiracy. They had local captains find plaintiffs, teach them their stories, give them playbooks of facts to memorize. They had a local lab involved in this conspiracy that would alter or create scientific results that weren't reflective of true fact. There was a local judge who was involved in this conspiracy who would fix local judgments in these cases. And again, this is not a conclusion that we reach based on our study. I mean, I'm just reporting on what a court in Los Angeles found after having conducted a hearing and taken evidence on all of these facts. As a result of this conspiracy, the actions that have been filed in the United States, two of them that were pending were thrown out. One, which resulted in a somewhat of a plaintiff's verdict. Hearings are going on right now to determine whether to throw that one out as well. In the judgment enforcement actions, a court in Florida, a huge judgment, hundreds of millions of dollars, was issued to a group of plaintiffs in Nicaragua by this judge who fixed judgments in domestically. The court in Florida absolutely refused to enforce it. It cited Law 364 and said it's fundamentally unfair. It violates our most basic notions of due process, and there's no way I'm going to enforce that judgment. Another enforcement action out in California, the plaintiffs actually got a judgment against the wrong company. They filed a complaint against the wrong company, and so what they did is they altered the evidence that they presented to the U.S. courts to try to make it seem like they'd gotten the judgment against the right defendants. Of course, the defendants knew that they weren't in the original lawsuit, and it was a bit of a stumbling block for the plaintiffs' lawyers, who nonetheless tried to pass off this false evidence as legitimate, and they've been also absolutely scalded by a recent finding from a judge who was appointed special master to look into this. So you look at the DBCP situation, and you've got this incredibly aggressive litigating posture. You've got all of these out-of-court tactics that are associated with it. You've got these potential rule of law concerns, and it's one of the reasons we picked this as a case study, not because it's necessarily typical of the cases that we looked at, but it is very revealing of the motive, of the tactics that are used, and ultimately the rule of law issues associated with these foreign cases. The second case study starts on page 34, and I'll mention it only for a minute. I'm sure you've all heard of this series of cases. This is the Chevron in Ecuador set of cases. A lot of similarities with the DBCP cases. The lawsuit originates in the United States as an alien tort case, an environmental case alleging harms to the environment as a result of activities by a Texaco-related entity in Ecuador decades before. The case is thrown out of the United States on forum nonconvenience ground, more appropriate to be filed elsewhere. While the case was pending, the lead plaintiff's lawyer in the United States lobbied to get a retroactive law passed in Ecuador, similar to the DBCP context. The lawsuit then was refiled. There were two lawsuits that were filed. One was filed in the United States in San Francisco as a personal injury case. And then, of course, there's the environmental case that has been filed and is currently being litigated in Ecuador. Accompanying these cases are all of the tactics. All 24 tactics that we studied appear in this series of cases. The media, the community organizing, the political, the investment. There are two media pieces I'll mention. I had clips of these connected to the PowerPoint, but I'll mention them. One was 60 Minutes, which conducted when I looked at it, I thought it sounded awfully friendly towards the plaintiffs, awful cozy with the plaintiffs. And a few weeks ago, just a few weeks ago, the Columbia Journalism Review did a fact audit of the 60 Minutes piece and reached the same conclusion that we did, which was this wasn't a fair presentation of the facts of the case, but did use improper evidence and created false impressions about the litigation, and says something like, even in this era of budget cuts, CBS could have and should have done better. The second I want to mention is the movie Crude, and I reference these only because they are probably how most people are getting information about these lawsuits, through the movie, through 60 Minutes, and the fact that it does have a pro-plaintiff slant to it is something that we certainly felt worthy of noting. Crude was a movie that was created by a director, a documentarian, an established documentarian. It primarily features the plaintiff's lawyers. They're on the screen throughout most of the movie. Every once in a while, it'll intersperse a response from Chevron. But as was revealed after the movie came out and in subsequent litigation that involves the movie, the way that this thing came about was the plaintiff's lawyer goes to the director and says, "Hey, make a movie about my clients." And he agrees and gives them access to the clients and to these internal discussions. Certainly no disclaimer, any type of statement along those lines is made about the movie when you see it. And one statement that I was going to play, it's very revealing in terms of the motives, and in our view, it's summed up very, very well, the motives for all of these cases. Plaintiff's lawyer, the U.S. plaintiff's lawyer who's assisting in this case, talks about the need to create leverage and the desire to create leverage, and it's only how much is the company willing to take before it gives in. And from our standpoint, it was a very poignant and revealing statement. We actually quoted, I think on page 34, right at the beginning that's the quote, on 34 at the beginning of the Chevron section. Want to very quickly touch on the rule of law concerns associated with this case as well, just as with the DBCP context. In the U.S. case, the case that was filed in San Francisco, alleging that a handful of plaintiffs were suffering from cancer, had contracted cancer as a result of petrochemical exposure. As it turned out, these injuries for half of them or so were completely fabricated, totally made up, weren't sick at all, absolutely invented, which was something that the plaintiff lawyer tried to cover up, according to the court. Again, these are judicial findings. And it took the company actually going into the rainforest to depose these guys and gather evidence to learn that these cases were made up. These illnesses were made up. The case has been since dismissed. And so I want to note it isn't just the litigation that goes on overseas, but it is also the transnational tort cases here domestically where we do have some of these issues. In the case, clear evidence that there was, for a judge who's now since been recused of judicial bias. As many of you know, there were videos taken, whether they illustrate corruption on behalf of the judge or not, people have disagreed on, but most certainly they show the judge expressing a clear sympathy for the plaintiffs and basically saying he's going to award $27 billion worth of damages. Overt political pressures on the courts. The president, Rafael Correa, socialist president Rafael Correa, has actively embraced the plaintiffs, made statements and campaigned with them. The independent expert who came up with the $27 billion judgment, as it turns out, used to be a paid expert by the architect of the lawsuit. He was a paid expert for him in an alien tort case that was being litigated here in the United States. Real questions about his independence based on that and other facts also have emerged. And so you look at the two case studies, and again, these aren't necessarily typical of the cases, but we do think highly illustrative of our bottom line conclusions. You see the tactics, you see the aggressive litigation approach, where the tactics are designed to augment a desired outcome, and you have these rule of law concerns that do crop up in both of these cases. By way of final remarks, again, we essentially reach just a few conclusions in this paper itself, despite its substantial length. Obviously, we do conclude there is a pattern, a clear trend to the four categories of tactics that we studied. You've heard about the motives, our conclusions about the motives for these cases, the holistic litigating approach, and as well as litigation as a tactic, the rule of law concerns that are associated with some of these cases, perhaps more so than on a domestic basis. We don't make a lot of prescriptive recommendations. We don't have a lot of looking forward thoughts or what should be done in response or anything like that. But I will note a couple of points, and then maybe other panelists can pick up on it if they so choose. Certainly, as a number of these cases reveal, there does need to be close scrutiny put on these cases when they're filed by courts and defendants. I mean, we've seen too many examples where evidence has not turned out to be what it was represented to not turn over every stone. And that will require both efforts from the defendants as well as from courts who may put certain limitations on discovery, and especially overseas discovery. There is the prospect for certain types of legal reforms that could be initiated both on state levels and on federal levels, depending on what the issues are. Certainly companies can consider their own tactical responses, knowing that these tactics are on the horizon when a lawsuit ultimately is threatened. And I expect our lunchtime speaker, Todd Buchholz, will talk a little bit more about some of the economic issues associated with these cases in the op-ed. We know one example where the tactics certainly seemed to work, and a company did divest from an overseas investment. But certainly, looking at these cases, companies obviously have to take the prospect into account that a relatively small investment for the company can yield big image-related problems, brand-related problems. And of course, if you're a company and you are going into one of these emerging markets and you choose to go forward, it is important to take into account that you're going to need to put in compliance efforts and other types of means of minimizing the prospect of litigation once you are there and planted. But that is my presentation. I will turn it over to the remainder of the panelists.
Thanks a lot, Jonathan. Can you hear me? Is this working? Yeah. Thanks a lot, Jonathan. We're running a little bit over, obviously, and just to give folks a heads up on how we're going to do this, I'm going to abridge slightly the panel. We're going to run the panel until 12:20, and then we're going to break. We're going to have to go out there for a reception while they turn the room over for lunch. And so we're going to cut the panel shortly and slightly, and then we're going to, when we come back, Todd Buchholz, we're going to actually have him speak while we're eating lunch so that we can make up a lot of this time, because there's no way. Normally we wait until after we've eaten lunch, but there's no way. We want to get everyone out of here on time, and that's the only way we're going to be able to make up the time. So it's our pleasure here to react to Jonathan's study with three experts who represent some of the best thinking out there, both from the government, from the academy, and from business. First, we're going to hear from David Stewart, who's a visiting professor of law at Georgetown, but for most of his career has been with the government. For 33 years was an attorney with the Office of the Legal Advisor to the State Department. He's published broadly on the area of international law, including being the co-editor or the co-author of the Nutshell on International Human Rights, as well as the author of a textbook on international and transnational criminal law. So we really look forward to hearing his comments, and he's particularly going to explain what we're talking about when we talk about the Alien Tort Statute, which is probably alien to most of the folks in this room if you're not attorneys or particularly attorneys that practice in this field. Next, we're going to go to Julian Koo, who is a professor of law and the associate dean at Hofstra University. Julian is, in addition to this, a law school classmate of mine, and I would suggest that Julian is one of, if not the most distinguished young scholars in this field. He's the co-founder of an international law weblog, Opinio Juris, that we regularly link from pointoflaw.com, the Manhattan Institute's web magazine, and he's published in a variety of fora, including the Yale Law Journal and the Supreme Court Review. He was a law clerk on the Fifth Circuit and attorney privately with Debevoise and Plimpton before joining the faculty at Hofstra. And then third, we're going to hear from Richard Ziegler, who has a broad career in business, from the business aspect of this. He's currently the managing partner of the Jenner & Block law firm, but before that he was the general counsel for the 3M Company in St. Paul, Minnesota, one of the largest corporations in the U.S., and therefore has been actively involved in lots of litigation from the business side of things, and I think he's going to really flesh out for us some of these tactics and how these international cases might parallel what we see in domestic courts as well. So we'll start with David, and each person is going to speak 8 to 10 minutes tops, and then we'll have a little discussion and open for questions.
Thank you, Jim, and congratulations, Jonathan, on your report, and congratulations to ILR. This is an important empirical study that actually will be essential reading in considering this topic as we move forward. Let me talk just for a few minutes about the Alien Tort Statute. And the most important thing to say is that I agree entirely with the report, with Jonathan's point, that there's something about this statute appears to invite or at least facilitate the kinds of litigation tactics that have been described to you this morning. Assuming that many of you are not familiar with the Alien Tort Statute, it's in the material, in the report on page 17. Let me just read it very simply. It's a short statute. The district court shall have original jurisdiction of any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty of the United States. That's all that's said. And for reasons that we don't have time to go into, no one really knows why the very first Congress of the United States adopted this statute in 1789. It's in the first Judiciary Act, in the first part of the first Judiciary Act. It's a jurisdictional statute. But there's really no record of why it was, what was on the minds of the Founding Fathers when they enacted this. One thing is clear to me, though, that it was not intended to allow suits against U.S. corporations in foreign countries. It was something quite different. My own view, debate at some length, is it was intended to allow Tories, I mean those people in the former colonies in the new United States who remained loyal to the king, to bring actions in federal court for damages done to them and their warehouses and their property during the Revolution. Why federal courts? Because they couldn't get satisfaction in state courts. So it was intended to be entirely a domestically focused statute. There might have been some aliens who were maybe in Canada or had gone home, but the focus was here in the United States. So that's one reason why there's no description of what the jurisdictional limits of this statute would have been, because everyone assumed it was only here in the United States. But as you can see, there aren't any limits. And what that permits, it has permitted over time, is for suits to be brought against entities in the United States, and people, individuals as well as corporations and as some governmental entities, for torts arising in other countries, having little, if anything, to do with the United States. These are acts that take place in different jurisdictions under different rules, according to different standards. People are attracted to litigating in the United States for some of the reasons that the report articulates: class action rules, contingency fees, broad discovery, potential for high damage awards, although there's very little prospect of enforcing those awards. Another thing that is sometimes overlooked is the standard of liability. If you look at the statute, it says tort only committed in violation of the law of nations. What that means in plain English is that the standard of liability isn't set. It's drawn from customary international law, and that permits an enormous range of allegations to be made. In almost every one of these suits, one of the big issues is what, in fact, is the tort we're talking about. That's allowed a lot of theories of secondary liability, for example, conspiracy theories, aiding and abetting, issues drawn from criminal law, particularly in recent cases from theories of international criminal law. In effect, the statute opens the door to bringing what are civil claims based on international criminal law theories against U.S. and other corporations for actions that take place abroad. So there's something in the structure of this statute that invites these kinds of claims and tactics. Secondly, I think the report is exactly right that in many, if not most cases, the statute is used for what I'll call impact litigation. That is litigation brought to make a point, either in whole or in part. Maybe it's a point about a certain policy objective. Maybe it's a point about an economic issue, perhaps certainly perceived social injustice, but often with little or no hope of actual recovery of damages. So these are suits that are intended to make a statement rather than, in many cases, to recover on the merits. One reason that's particularly troublesome is that the judgments rendered under this statute in U.S. courts are virtually unenforceable in any other country because no other country has anything like the Alien Tort Statute. They wouldn't recognize a judgment based on this jurisdiction. So that, again, there's something about the statute and the way it works that invites what Jonathan has called the holistic approach, litigation approach. U.S. courts then are becoming, in a sense, the human rights courts or the trade and investment policy courts for the world, hearing things that have nothing to do with the United States, and many of these cases are articulated in your report. Now, I don't mean to suggest, and I'm sure that the report doesn't mean to suggest, that many of these cases are not without some underlying merit. I mean, none of us would support the proposition that companies that engage in bad behavior, let's say if they participate in acts of genocide or commit war crimes or engage in serious environmental damage or anything like that, should not have a liability and should not be held accountable. The question is more subtle, whether they should be held accountable in U.S. courts for things having nothing to do with the United States, or in some cases whether the suits are brought against the corporations as on a theory of secondary liability because the litigants can't get at the governments, the foreign governments, which are in fact responsible for the activities that go on in their own country. We'll take a few cases that Jonathan has mentioned. For example, Talisman in Sudan is one of a number where the actual gravamen of the litigation involves the government, but the litigants can't get at the government because of immunity, so they choose another more plausible target. Well, the final question that I want to mention was raised by Jonathan at the end. That's what to do about all of this. What's the downstream object, I think you called it, what prescriptive recommendations can we make? One thing is clear to me, these suits are not going away. It's globalization, economic interdependency, expanding world markets, increased transnational activity increase, so will these torts, transitory torts increase. Corporations, as I said, like people, should, of course, be held accountable for if they do bad things. Question is where and under what circumstances. So perhaps in the long term, the international community needs to address the issue of transitory torts. At the moment, there's no regime that governs this in international law. There's no rule that says it's unlawful for U.S. courts to exercise this kind of jurisdiction. Perhaps expanding efforts at rule of law, increased ethical standards, increased due process sensitivities in foreign courts are what to do. Perhaps at some point there will be an international human rights court. Not a prospect that has ever excited the U.S. government particularly, but one could see that as taking these things out of domestic courts. For the short run, and this is my last point, I think that what really is necessary is increased sensitivity to the kinds of tactics the report articulates and increased need for courts that are faced with these litigation situations to supervise them closely, both the parties and the attorneys, and that's the real benefit of this report. Some of you may be thinking, yeah, well, why not reform the Alien Tort Statute? I'd be all in favor of that, but that's a different topic altogether. Thank you.
Thanks, David. Julian.
Thanks. I'm gonna thanks also for the Manhattan Institute and the the ILR for inviting me to participate. Like David, I very much commend and admire the work done by Jonathan and his team. As an academic, I'm just always impressed by this kind of really extremely rigorous and comprehensive research and gathering of enormous amounts of data, and I need to get my research assistants working on that to sort of try to keep up with that. Because I have been actually pursuing a similar project on litigation under the Alien Tort Statute. This is generally an area that I've been very interested in: international litigation, transnational litigation invoking international law. And I think this report, from my perspective, is an important contribution to understand how domestic U.S. defendants are being impacted by what I would say is the growth and evolution of international and transnational tort litigation, which I myself was not as aware of before I read this report. Now, his paper self-consciously focuses on out-of-court tactics, and as opposed to legal doctrines underlying these tactics, and I think that's a part of the value of the report. In my comments, though, I'm going to focus on some of the legal doctrines, and so, like my students, we're going to go back to the law. We'll ignore the facts, because we don't like facts in law school. We'll talk about, I want to talk about some of the way the doctrines that underlie these types of transnational lawsuits, sort of, as David mentioned, invite or at least facilitate these sorts of out-of-court tactics, and also try to assess really briefly whether these types of transnational tort litigations and their accompanying tactics are likely to grow in the future. And the two most important areas of legal doctrine, at least implicated by this report, I think, by this sort of transnational litigation, are one, the standards for bringing cases under the Alien Tort Statute, and I think David has already discussed and mentioned that. And two, what I'm going to try to focus my remarks on, the standards governing the enforcement of foreign judgments in U.S. courts. Now, these two doctrines, I think, have a big impact on the incentives for plaintiffs to bring these sorts of lawsuits, and if the standards, for instance, are really hard or restrictive, plaintiffs will have a disincentive to actually bring these lawsuits And perhaps if we change the standards, perhaps there would be some impact on the likelihood of these lawsuits continuing. Now, let me sort of focus on the standards governing the enforcement of foreign judgments in U.S. courts. This is something which has not received nearly as much academic attention, or in a lot of ways attention from perhaps even the practicing bar, as much as perhaps the Alien Tort Statute cases are. And I think that the enforcement of foreign judgments, though, turns out it might be actually a very important part of the menu of options for international plaintiffs seeking to bring transnational tort litigations. Because one of the most striking sort of revelations, at least to me, in the report, is the growth of massive, sort of what I always described in the past to my students as U.S. style, right, huge, massive tort judgments, which we traditionally called U.S. style because it was inconceivable that anyone could win a $27 billion judgment outside of the U.S. court, and even, frankly, in a U.S. court. Now, traditionally, I believe the conventional wisdom among U.S. lawyers was that foreign jurisdictions would never grant civil liability awards on the scale of the U.S. court. And it was a safe tactic, therefore, for corporate defendants and their legal advisors to say, argue forum nonconvenience. In other words, to argue when you're faced with a case involving transnational activities or activities abroad, argue forum nonconvenience, argue that this case should be dismissed from U.S. court, not on the merits, but on the grounds that there's a forum that's more convenient, more appropriate, and this court forum is not appropriate. The forum that's more appropriate is the jurisdiction where the actual alleged torts occurred, and this has actually been, I think, a traditional and very effective strategy for the defense bar over the years, which has led many courts to dismiss transnational litigation to foreign courts. And what's interesting to me about the report, one of the interesting things to me about the report, is how the case studies highlighted in the report, the Nicaragua cases involving, I always forget the acronym, DPCP, some mysterious chemical, like pesticide, and the Ecuador case studies. Both of them involve judgments obtained in a foreign jurisdiction, and potential really large judgments, nothing to sneeze at, maybe nothing that would get a Mississippi plaintiff's lawyer really excited, but something, $27 billion, I think anyone would take that one, right? Or even $100 million, right? Nothing to sneeze at. And this is for a foreign jurisdiction. This is, I think, a relatively new phenomenon. These are pretty enormous judgments, and any plaintiff's lawyer in the United States would be very proud to have a judgment like this one. Now, as a practical matter, unless the corporate defendant has a lot of assets in the foreign jurisdiction, one of the important battlegrounds is going to be whether that foreign judgment can be translated into a U.S. judgment. In other words, whether you can bring that foreign judgment, take it to U.S. court, and get a U.S. court to enforce payment of it. And so that's why I think this area of doctrine is which has been, at least in my view, relatively understudied and unappreciated, might be an important going forward, and that's what this report at least reminds me of. In general, most U.S. jurisdictions are very favorable to the enforcement of judgments obtained in foreign courts. Now, this sort of goes, this has changed perhaps over the years, but in general, that's been the story about U.S. courts, and that they've done so out of a spirit of comedy and respect for foreign courts and foreign judicial processes. But most U.S. jurisdictions do permit a few important defenses to the enforcement of foreign judgments, and I think they're encapsulated in Section 4 of the Uniform Act for the Enforcement of Foreign Money Judgments, which I don't even know what the acronym of that is. There's no good acronym for it. But they basically these defenses, in other words, if someone walks into a Florida court, as they did in the Nicaraguan litigation, with a $100 million judgment from a Nicaraguan court, and they want a Florida court to enforce it, the attorneys for, in this case, the corporate defendant Dole, could argue, and did argue, things like, well, there's a lack of due process in the foreign jurisdiction. The judicial tribunal was not impartial. The second big argument is typically there was no actual personal or subject matter jurisdiction in that foreign court. That's one actually that could not be argued, probably in that case. There's a lack of notice, or the enforcement of the judgment would be contrary to the public policy of this jurisdiction, of the enforcing jurisdiction, the home jurisdiction, or, as was applicable in many of the case studies described in the report, the judgment was obtained by fraud. And these defenses, I think, are pretty adequate, and they were successfully invoked by the defendants in the Nicaraguan litigation in a case called Osorio versus Dole, the enforcement action flowing out of one of the Nicaraguan cases. And the district court pretty much, read down the list and said pretty much all of them are grounds for refusing to enforce this judgment from Nicaragua. So far, so good. I mean, so you might be facing, I think, ugly out-of-court tactics and ugly internet campaign. You might be facing perhaps a really ugly judgment in Nicaragua or Ecuador. But you at least have some protection because of these standards, I think, for enforcing foreign judgments. And let me sort of issue a couple cautionary notes about the doctrine. First of all, as is implausible to many international sort of lawyers, but sometimes they don't realize this, but in fact, the standards for enforcing a foreign judgment, even a foreign meaning from a foreign country outside the United States, the standards for enforcing these judgments is a question of state law, not federal law, right? And so, as not surprisingly, they're governed not by any federal statute, but by the Uniform Act that I mentioned, which has slowly been adopted over the years by most jurisdictions, including, I think the number is up to 47 even states have now enacted it. But even so, the Uniform Act, some folks have noted that it at least opens the door for some possible disuniformity. Let me just mention there's two areas of disuniformity that could potentially open the door for some jurisdictions to be much more deferential in enforcing foreign judgments. First, I think that there's this Uniform Act alone and the general standards followed in U.S. courts have given a lot of discretion to the individual judge in recognizing a basis for foreign jurisdiction. So in some cases, not in the cases we discussed here, a court in a foreign jurisdiction might assert a power over a particular case, even though it had no relationship to Nicaragua or whatever jurisdiction either, right? The plaintiff and the defendant had never appeared there or had only indirectly had some context there. But Section 5 of the Uniform Act does permit courts to recognize any other basis of jurisdiction that the court deems would be acceptable, even if they weren't acceptable here in the United States. And this has not really been explored very much, but this has been noted by some scholars might open the door for a judge to recognize an extreme form of, say, subject matter jurisdiction from a foreign court. And second, there's also a lot of disuniformity among the United States among whether a reciprocity of enforcement requirement should be required. In other words, generally speaking, some states in the United States say, well, we won't enforce unless the other jurisdiction will enforce U.S. judgments. But some states say no, and some states say they don't know. Some states leave it up to the individual judge. And basically what we have is a bit of a patchwork out there. And the Uniform Act itself refuses to address it because it's too controversial. And so this does leave the room for particular states. Some states are likely to require reciprocity, approving reciprocity. Some states are likely to not require approving reciprocity. Some states might leave it up to the particular judge in question. And disuniformity among these states is usually understood as a disadvantage to U.S. plaintiffs because it makes it harder to enforce these sorts of U.S. judgments abroad. And one of the problems with in other words, it's hard to convince a court in some other country that we have some sort of standards here because our standards are all over the map. On the other hand, disuniformity does work potentially to the advantage of U.S. plaintiffs or foreign plaintiffs who are trying to enforce in the United States because they might find that jurisdiction that is sort of free to under a particular state law and with local judicial discretion to adopt a very favorable standard for enforcing foreign judgments in U.S. courts. And so I think that has that's a potential, small perhaps and unexplored, but a potential window in the future that could open the door to, if foreign jurisdictions continue to be open to these large tort judgments, to finding a jurisdiction in the United States that would be open to a much more deferential and friendly enforcement regime of foreign judgments, in which case you might see corporate defendants facing pretty serious judgments in foreign jurisdictions, and U.S. courts simply going ahead and enforcing them. We haven't seen that yet, but I think that's something that people are worried about down the road. There's a lot more law here to talk about, but I'm not going to go into that in sort of too much detail. So I think, and I also just want to briefly echo all that David said about the Alien Tort Statute, which is the other main legal avenue for bringing these sorts of transnational lawsuits. I think that the Alien Tort Statute is sort of an interesting example of the opposite problem. I think you bring the lawsuit here in the United States, and you fight hard to bring the lawsuit here in the United States. And I think the the interesting thing about those alien tort statute cases, as David mentioned, that the legal standard it's not so much the legal standard is much less clear than in the enforcement of foreign judgment context. The law can be developed much more by the courts here with a lot more judicial discretion, and I think this is why it's uniquely attractive to foreign plaintiffs in these transnational cases. Let me also just mention one thing, which is something we don't always talk about, perhaps in the practicing world, but there are groups not, as David mentioned, not motivated by obtaining a large tort judgment, but simply by proving a point, and something Jonathan mentioned as well, that one of the main ideas, one of the big supporters of the alien tort statute in the United States is actually, I think Jim and I both took a course with him at Yale Law School, Harold Koh, who's now the State Department's chief legal advisor. And he was, among other things, famous for developing a theory as to why these sorts of alien tort statute cases would be valuable, whether or not, and he didn't really care much whether they actually won judgments, but it was to develop norms of international law. It was to make or develop points of principle. And it was really important to bring these cases, at least in the theory that Professor Koh developed, because they would establish important principles of international law, whether or not anyone was that U.S. courts would recognize. And it didn't really matter, perhaps, what the underlying facts were in the particular case, as much as establishing this point. I think this is part of the motivation. In other words, the litigation itself is an out-of-court tactic. We don't expect to win. We're not necessarily going to win that much money off this case. We have a lot of legal obstacles ahead of us. But there's a lot to be gained from developing this norm of international law. And I think there are groups that have, this is not to criticize them, but have sort of embraced this idea of this is important to develop norms of international law, to make the United States courts recognize norms of international law. This also, I think, is one reason why we see concerted sort of public relations campaigns that are in concert with these sorts of lawsuits. Let me just conclude here briefly by saying, again, I salute Jonathan's, the ILO's important report. I think, the PR war becomes at least as important as the court litigation in many of these cases, maybe more important in some of these cases. From a doctrinal perspective, I share David's view on this, that I don't think these types of cases are likely to diminish in the near future, absent political action by Congress to either create federal statutes, uniform federal statutes that would regulate the enforcement of foreign judgments, or the long-awaited but never actual amendment to the alien tort statute, which will never, ever happen in my lifetime, I guess. So corporate defendants, I think, should continue to battle. I mean, not that I'm saying this is a good thing, but to continue to battle in what is now an expanding transnational litigation environment. Thanks.
Thank you, Julian. Richard.
Thank you. If this is on, I will address 2 points in these remarks. First is just to provide a little comparison and contrast between what we've heard about the elements of out-of-court tactics in transnational litigation and some similarly abusive domestic tort litigation. And then the other point I will address, which both Julian and David have to some extent, is what can a defendant do about it? So starting with the parallels, I must say I was struck early on in reading this report in the executive summary at page 6 with the parallel of some of the conduct to asbestos in silica litigation, of which I am regrettably a veteran. On page 6, the report states, quote, as judicial findings detail, they, referring to the plaintiff's lawyers, engaged in a variety of dubious practices to enlist clients, many of whom never worked on banana plantations or suffered the injuries alleged, and taught them their stories. They also engaged in a conspiracy with laboratories to fabricate scientific evidence, and with a local Nicaraguan judge to fix judgments in Nicaragua for later enforcement in the U.S. Well, if you take a look at the Manhattan Institute's report of 2 years ago entitled Trial Lawyers Inc. Asbestos, you'll see essentially all of those tactics, all of those abuses were pursued in various times and in various courts in asbestos litigation in the United States, having nothing to do with the alien tort statute. Certainly, plaintiffs' lawyers engaged in dubious tactics to recruit clients involving using X-ray machines to take chest X-rays without a doctor's prescription in vans that would pull up to factory gates and shopping centers and, in effect, offer $1 million jackpot to any person, ironically, lucky enough to have a spot or opacity determined on a chest X-ray. There was quite a controversy some years ago with the law firm Barron and Budd in Texas, one of the leading asbestos firms, when a worksheet given to prospective plaintiffs was disclosed and seemed to indicate how the plaintiffs were being taught stories on how to identify asbestos-containing products that they were exposed to. Certainly, in the silica litigation, the seminal decision of Judge Janice Jack in federal courtroom in Corpus Christi, Texas, back in 2005, exposed, complete with radiologists taking the Fifth Amendment in her courtroom, abuses of the medical profession in providing diagnoses based on the chest X-rays from the mobile vans. And of course, both the ILR and others have identified the hellhole jurisdictions right here in the U.S. of A, where one could not necessarily rely on the justice provided by certain state court judges. So, to that extent, some of these tactics are not new. On the other hand, I think the report is pretty eye-opening in showing how other sets of tactics, and I think the report quite conscientiously points out that those really dramatic, unethical, probably unlawful abuses that I just referenced on page 6 are identified essentially in 2 of the cases, but not in the others. Doesn't mean it hasn't occurred in some respect in the others, but there's certainly no evidence that it has. So the report quite carefully focuses on the other categories of out-of-court tactics, the media, the community organizing with the non-governmental organizations, the investor pressure, and the political pressure. And I think that does depart from what the experience has been in domestic tort litigation. Certainly some of that existed in asbestos and silica. Certainly media stories were pretty prevalent. In environmental domestic contamination litigation, NGOs frequently get into the act and communities are organized. But I think the combination and that interesting appendix at page 83 of the report, which puts in the X's for the intensity of the use of this variety of tactics, does suggest that there is something new on the scene here that is being exploited in the transnational tort litigation arena. So that leads to the next question: what is a defendant supposed to do about it? And both David and Julian addressed some of that, and I will put my 2 cents in. Of course, the first thing to do about it is to make sure that the corporate America conducts its operations abroad in a manner that if it is challenged, they have nothing to be defensive about. That is quite a challenge because, as you all know, with globalization, it's not as if U.S. multinationals have built their own production facilities or their own extractive facilities abroad. They tend to outsource these things to local entities. And as one of the cases that are described in the appendix of this report shows involving Walmart, the claim was that Walmart had a pretty good or maybe wonderful supplier code of conduct, that the outsourced manufacturing facility in whatever emerging market it was supposed to be treating its workforce properly. The allegation, I have no idea whether valid or otherwise, was that the workers were exploited in a variety of, according to the allegations, pretty serious ways. Walmart presumably has, as part of its code, an effort to monitor its outsourced facilities And that's important. It's really difficult, and it's really difficult if you don't know what the standards are. And interestingly, what I'm hearing from Julian is that our current State Department legal advisor, Harold Coe, is all in favor of broader use of the Alien Tort Statute because it allows the U.S. federal courts, if I heard this right, to develop as a matter of common law what the international norms are for treatment of private business employees around the world. A fascinating question whether, particularly in a globalized world, that is an appropriate way to set norms and standards. There are other norms and standards out there in the world now. The UN has some. I think the ISO has some. There are other standard-setting bodies. A business needs standards, and while the common law and the development of the common law to set standards is a wonderful thing, and we're probably going to see it played out with respect to what the right standard is for drilling an 18,000-foot well someday soon, it is really tough to run a business and not know what standard your operations or your outsourced operations will be held to. Many reputable U.S. multinationals make it simple on themselves and apply U.S. standards, at least for most issues, environmental and labor. That is very expensive. It can defeat the purpose of going to Thailand or Vietnam or wherever to have the production facility in the first place. So it is a difficult task. It is the necessary first step, it seems to me, in the defendant's playbook, is to come up with a set of standards and comply with them in a way so that there's nothing to be defensive about if an allegation comes in. That, of course, doesn't do much good if the statute of limitations allows a plaintiff to bring a claim that goes back 25 years when everybody's standards were different. And so there is an interesting separate kind of fairness issue to both sides on whether a court in 2010 should be applying 2010 standards to conduct that occurred decades earlier. Once one is confronted with the litigation, I think, as Julian has said, there's a really interesting question whether to apply what had been the standard defense play, which is if you're sued in the U.S., try to get it dismissed on forum nonconvenience ground because while the plaintiff can theoretically sue in its home forum, the plaintiff probably won't do that for the variety of reasons that there isn't a well-developed contingency fee plaintiff's bar in the plaintiff's home forum, that if a lawsuit is brought in the plaintiff's home forum, the perception will be, particularly if it's a civil code jurisdiction, as most are around the world, that there won't be a jury who could impose essentially unlimited damages. And thirdly, in this foreign locale, there won't be any real discovery because, as we all know, that is essentially an American litigation phenomenon. Well, the experience of in the two case studies that are illustrated in this report shows that maybe that's not the best tactic in the world, that both in the Nicaraguan and Ecuadorian cases, those cases were initially filed in federal court in the United States. The defendants succeeded in getting them booted out, and I'm sure that there was a celebration when those forum non-dismissal motions were granted in those two cases. But they're not celebrating because it turned out the plaintiff's bar moved to Ecuador and to Nicaragua, and in league with these other tactics that we have seen, managed to get whopping judgments. Ironically, it could prove to be the case that because those judgments were apparently obtained by fraud, that when it comes to enforcing them, as Julian was talking about, where the assets are, in both cases in the U.S. of A U.S. court isn't going to enforce them. So while they may have gone through an awful lot of Sturm und Drang, it is possible they are still better off having moved to dismiss on forum non-grounds, litigated a nightmare in these two other jurisdictions, but without any assets in those jurisdictions where those nightmare judgments can be enforced, and then have a wonderful defense to any enforcement when the plaintiffs come to the U.S. to enforce them. Whereas if they had never sought to dismiss on forum non in the first place, they would have been subject to U.S.-style discovery with a U.S. jury, and while it wouldn't have been a $27 billion judgment, there might have been some judgment, and the assets would be there to back it up. So I think the lesson is one can't just assume a forum non-motion is the right approach, but it still is possible that it might be. The other lesson is you're going to make those judgments unenforceable only if you do an incredible amount of homework. And there was a fair bit of luck involved in both the Nicaraguan and the Ecuadorian cases in identifying the fraud. The banana one struck me as pretty straightforward because my memory is that the pesticide at issue allegedly sterilized the workers who were exposed to excessive levels of it. And the defendant was able to establish that a lot of the plaintiffs had kids. And so that was a relatively straightforward way to expose at least one of the problems. But a real lesson, whether it's in domestic abusive tort litigation, in Judge Jack's wonderful 250-page opinion revealing the abuses in the asbestos and silica arena, or in these two transnational incidents, is the defendants have to do their homework, which takes incredible resources, and it takes a commitment to resist what may be the easy and less expensive way out in the short term. I think a next arena in the defendant's playbook is the incredible importance of maintaining, as a company, wholly independent of one's litigation docket, positive relationships with the constituencies that the out-of-court tactics are designed to influence against the company. That starts with the company's workforce. There's no more powerful set of potential supporters or detractors from a corporate defendant than the people who work for that corporation. And so part of the playbook has to be to maintain good relationships with the workers. Institutional investors and the Wall Street analysts come next, because if one has a credible relationship with one's major stockholders and with the folks from the broker-dealers who are writing the reports and are on the investor relations calls every 90 days, then when some litigation comes in that has an ad damnum of $20 billion and one says, well, we don't think there's any merit to it, and don't be taken in by what you may be seeing on YouTube. If one has established that credibility, it's going to carry you a long way. And similarly, having sound relations with the elected officials, regulators, and if you're a consumer products company, your consumers are going to do it. And I suppose the last tactic in the defense playbook is to attempt to harness the media in reverse. Plaintiff's playbook is to exploit it to their advantage. Part of the dilemma of the decline of the mainstream media is, at least if the mainstream media runs a story that is one-sided and fed misleading facts by the plaintiff's side, you have an editor or a publisher whom you can go to and try to get a correction run. Nobody will read the correction, but at least you have the satisfaction of having corrected the record, and the plaintiff's expert can no longer rely on that news story as a source for the plaintiff's expert's conclusion, if in fact there's I have personal experience with this, so it was quite important. But if you're doing a non-mainstream media, if it's all blogging and viral videos that are making the case against you, you've got nobody to complain to. So this report, it seems to me, is a very important step in helping to harness the media to expose the potential for abuse. So I congratulate the author and the sponsors.
Thank you, Richard. We do have to break and almost immediately to be able to clear for lunch. If there is a question or two that is short and is an actual question, I'll entertain it at this time. Ed.
Anyway, much better. Have there been any Rule 11 sanctions against the make-a-point litigation, which we used to call vexatious litigation? And secondly, are not foreign courts as susceptible to pressure by their government to protect companies which have jobs there as they are by the people who seek to go in the other direction?
Sure, let me stand up because I think the podium is blocking part of the view from this side. On the Rule 11 piece, yes, in the DBCP cases, there have been Rule 11 sanctions issued in some of the earlier cases that were called vexatious forum shopping. In the cases that do involve the conspiracy to commit fraud, the fraudulent conspiracy that I outlined before coming out of Los Angeles, the court did recommend sanctions and make a bar referral. Those are still pending. Same with the judgment enforcement action I mentioned as well. Those haven't reached final resolution yet, but yes, there were sanctions and bar referrals that were made. The second question was... Yeah, the political influence. I mean, what we tend to see, absolutely, there can be a protection of foreign investment for companies that come in, and obviously a desire to protect that. And that's one of the reasons that there's been a perceived need to file cases in the United States as opposed to in the foreign courts. It's anticipated there'll be a chilly reception based on foreign governments' desire to have U.S. and other multinationals come and invest. I think when those U.S. multinationals, though, cease their investment activities and depart, that's when the greatest vulnerability exists, and that's true both in the Ecuador sense and in the DBCP context that we look at. So I think while you have functioning multinationals who are presenting a substantial royalty base and obviously employment, it's one thing, but it might be different once they do pick up and move out.
Right here, and that's going to be the last one. I'm sorry. We can have people can come up individually and ask questions.
Thank you, Richard Field. Have you seen in these cases a distinction between what you call the sort of the greed cases and the cause cases? And if there is a distinction that you could segregate those two, different tactics, particularly for the cause cases, is litigation less and less important? Are you seeing categories where all these other tactics are being used without the litigation piece?
Well, I think that the conclusion, certainly, there are a few different conclusions that may go to this point. Number one, we see a lot of partnering up of traditional plaintiffs' lawyers and NGOs and public interest lawyers. And certainly, I reach the conclusion that there's a symbiotic effect there. The traditional plaintiffs' firms have the resources to litigate these big, difficult cases. They're given a veneer of doing good from the NGOs. So the NGOs provide that level of integrity or authenticity to the plaintiffs' firms who ultimately can collect substantial judgments. The second point is, I think we see these tactics, the NGOs and public interest firms use these tactics probably more than the traditional plaintiffs' firms. I mean, they take investment, they take time, they take effort. Certainly the traditional plaintiffs' firms will use them, but I think that you see more coming out from the public interest firms and the NGOs than you do from the traditional plaintiffs' firms when these things can ultimately be separated out. And that's not to say they aren't used to a large extent by the plaintiffs' firms, but I think there's a greater use of the media. I think there's a greater sense of investment pressures. All of the tactics, the political tactics, you do tend to see a greater frequency when it's the NGOs and public interest firms that are driving it than the traditional plaintiffs' firms.
Okay. Let's thank everybody. Please, very quickly.
I think it is clear how fortunate we are to believe in the power of ideas.
Supply the common sense and the fresh thinking of the Manhattan Institute.